This is Michael Popok, Legal AF. Sometimes you have to pan and sift for gold inside of a Jack Smith special counsel filing against Donald Trump in the criminal case in the District of Columbia. We just had such a filing, and buried on page 19 of a 22-page motion, we have a revelation. We have new information that indicates the strength of Jack Smith's case, particularly the type and quality of witnesses he's going to bring in through the back door of that wood-paneled courtroom against Donald Trump in front of a jury starting in March. What am I talking about? I'm talking about a section of the brief on what we call a motion in limine to preclude certain evidence from being introduced or certain conduct from being executed in a courtroom by Donald Trump that's been filed by Jack Smith. And particularly, Jack Smith is telling the world through his filing that some of his witnesses are members of Congress, are likely Mike Pence, and attorneys that used to work for Donald Trump are going to be paraded one at a time ad seriatim into that courtroom to testify in front of that jury. We always want to, on Legal AF, astral project ourselves into the courtroom. It also helps clear the mind that's been cluttered by Donald Trump's constant haranguing misinformation campaign, disinformation campaign on social media, right-wing cupcake interviews, and rallies. And when you only focus, as I do as a trial lawyer, on what is going to happen in the courtroom as you project yourself there and think about sitting in the courtroom, the smell of the paneling of the courtroom, the jury rapt attention in the jury box, in the hands of a masterful prosecution presentation, the evidence, not just documentary evidence, documents that can lead to eyes glazed over and flatlining by the jury, but live witnesses in a courtroom and who they will be and what stature they will have that will change the weather in the room against Donald Trump. That's what I always think about when I think about this case. That's what I think about the magnitude of the prosecution's mountain of evidence against Donald Trump on that scale of justice. Yes, they've got the heightened burden to prove that beyond a reasonable doubt, but look at the mountain of evidence, and we only know about the tip of that mountain, of that iceberg. We don't even know about all of it. Only when we get filings like this is it more fully revealed. How do I know that Jack Smith's going to be bringing in members of Congress, former members of Congress, and Mike Pence and attorneys for Donald Trump? Because he referenced two things as special messaging, and here's the decoder ring for it. Speech and debate privilege means Mike Pence or members of Congress when that's referenced. So when you hear that term, and I'm going to show you where that is in the motion in a moment, think Mike Pence in his ceremonial role in the Senate to confirm the results of the electoral votes to certify the election, and the speech and debate privilege that applies to that. When you hear attorney-client privilege, it's obvious. Think about all the former attorneys for Donald Trump, many of them indicted or convicted already, that will testify against Donald Trump, whether they want to or not, and what the Jack Smith, in its recent filing in the Court of Appeal, in the DC court with Judge Chutkan, what he is proclaiming, what he is requesting, is that Judge Chutkan not go through the charade that Donald Trump wants to use in the courtroom and embarrass these people and make in front of the jury, whether they're asserting a privilege or not, become a thing. Because it shouldn't be a thing in front of the jury. Because the jury that's not well trained, and even if they are instructed, they may take away they may make the wrong takeaway. They might think the person's not being candid. They may think that the person who's testifying is not being honest. And Jack Smith doesn't want it to go to their honesty or candor if they're properly asserting the privilege of attorney-client privilege or speech and debate privilege. He wants all of those issues done outside the prying eyes of the jury when it's just lawyers and the judge in a pre-trial evidentiary hearing where they argue about the application of the privilege, whether the person has the privilege, and all that gets sorted out with that witness's lawyer, the judge, and Donald Trump and and Jack Smith's team before the jury even knows about it, so that it's not done in front of the jury, this sausage making, which will only confuse them as to, well, if the person's honest, why are they asserting the a privilege? I want to hear from them. And that's what could happen to a jury like that. Real talk. 52% of men over 40 experience some form of ED between the ages of 40 and 70. Personally, all of my friends, once they hit 40, started using something to help, whether they admitted it in the locker room or not, because it's always been a taboo topic. Thankfully, HIMSS is changing that by providing affordable access to ED treatment all online. HIMSS is changing men's healthcare by providing access to affordable and discreet sexual health treatments, all from the comfort of your couch. HIMSS provides access to clinically proven generic alternatives to Viagra and Cialis, up to 95% cheaper, with options as low as $2 per dose. The process is simple and 100% online, no uncomfortable doctor's visits. Answer a series of questions on their site, and a medical provider will determine the right treatment option. If prescribed, your medication ships directly to you for free and in discreet packaging. No insurance needed. Pay one low price for your treatments, online visits, ongoing shipments, and provider messaging. HIMSS has hundreds of thousands of trusted subscribers, so if ED is getting you down, it's time to change that. Start your free online visit today at hims.com/legalaf. That's HIMS.com/legalaf for your personalized ED treatment options. hims.com/legalaf. Prescriptions require an online consultation with a healthcare provider who will determine if appropriate. Restrictions apply. See website for details and important safety information. Subscription required. Price varies based on product and subscription. What I'm talking about in particular is on page 19 of this motion in limine that was just filed. The headline says, the court, meaning Judge Chutkin, should prohibit cross-examination attempting to elicit irrelevant protected information. That's privileged information. And the brief goes on to say the government anticipates calling witnesses with knowledge of information protected by certain privileges, including the attorney-client privilege. I'll talk about the list of people there that we anticipate that applying to, and the speech or debate privilege. And that's a smaller group that's led by Mike Pence. If questioned about such information, those witnesses reasonably could assert the privilege that attaches, if the privilege hasn't already been stripped away from them by a court proceeding, which I'll talk about next, as it relates to many of the attorneys for Donald Trump. The defendant, Trump, should be precluded from questioning witnesses about otherwise protected information on cross-examination unless he receives pre-clearance from the court, meaning until there's a court process without the jury involved to make the ultimate decision on the privilege. He should not be able to question them, and then the witness is in an uncomfortable position of taking the privilege in front of a jury, looking like he's not being or she's not being candid. The brief or the position of the government goes on. Allowing the defendant to question witnesses about information for which a witness either must or would be likely to assert a privilege in open court in front of the jury runs the risk of unfairly and improperly suggesting to the jury that the witness lacks candor and presenting to the jury otherwise inadmissible evidence. There are many legitimate reasons a witness might invoke a privilege. For example, the brief goes on, the government goes on, the privilege may not be the witnesses to waive, like in an attorney-client privilege. It's the client's privilege, not the lawyer's. Or the witness may deem it necessary to invoke the privilege for institutional rather than personal reasons. That would be like, the lawyers that work for Donald Trump in the White House, like Pat Cipollone or Eric Hirschman. They're trying to take a position about future White House counsel. So it's an institutional decision, not a personal one. The brief goes on. None of these purposes bear on the witness's candor, bias, or any other relevant consideration for the jury. And any out-of-court statements or other evidence the defense, the Trump side, might use to press the privilege claim would be irrelevant and inadmissible. Accordingly, such cross-examination is improper, citing a line of cases on that point, and therefore should be banned. Now, let's leave the brief and return to reality. Who's he talking about? Who's Jack Smith talking about on the attorney-client side? And what is the status of the privilege related to Donald Trump on each? Let me go through the lawyers that we know have testified before the grand jury and or have been indicted and or are convicted, who worked at one time for Donald Trump and the White House. Evan Corcoran. Evan Corcoran represented Donald Trump for all things Mar-a-Lago until he didn't. He was brought into the grand jury. His attorney-client privilege was stripped from him because Judge Beryl Howell of the D.C. Court of Appeals, the D.C. Circuit Court, who was the chief judge at the time, ruled based on the evidence presented to her in a secret hearing about the grand jury that Donald Trump and Evan Corcoran, it was more likely than not that a crime and fraud was committed by Donald Trump and therefore no privilege. Evan Corcoran, his testimony about Donald Trump's interactions with him and instructions with him to obstruct justice in Mar-a-Lago were all presented to the grand jury, as were 50 pages of notes related to his representation of Donald Trump. He has an impact as well on the Jan 6th prosecution, and he could testify. He no longer has attorney-client privilege, so I don't think that is what Jack Smith's referring to there, because Corcoran can now freely testify. The decision about privilege has already been decided. Christina Bobb, who continues to be a lawyer and a shill for Donald Trump on various social media outlets and interviews. She was involved with Mar-a-Lago, and she was an attorney for Donald Trump, and she had her attorney-client privilege stripped as well. Jennifer Little, also involved with Mar-a-Lago, she could assert a privilege. Alina Habba, who was involved with searching Mar-a-Lago and other relationships to Donald Trump, continues to hold the privilege, or Donald Trump does, but she could be called in to testify about certain things as well. Although that's more of a Mar-a-Lago issue than a Jan 6th issue, there could be some overlap. Then you've got the group that is relevant and probably still retains the attorney-client privilege until it's adjudicated that they have not. And that's the Georgia lawyer defendants who have all pled guilty. Sidney Powell, Ken Chesborough, and Jenna Ellis. They technically still have the attorney-client privilege between themselves and Donald Trump because it hasn't been adjudicated yet to be removed. And therefore, because they're in the Georgia process, although they already pled guilty to crimes. But there has to be a process, and that's what I think Jack Smith's referring to here in the motion. Really, Powell, Chesborough, and Ellis. Ken Chesborough, the architect of the fake elector scheme. Sidney Powell, involved with Donald Trump's considering declaring martial law and suspending the Constitution and using the military to cling to power, among other, and all the lawsuits, the phony lawsuits that went 0-70 against Donald Trump, and Jenna Ellis, the same thing, and assisting Rudy Giuliani. That group still has to have the attorney-client privilege resolved by a judge, and that would be Judge Chutkin, and not in front of the jury, is what Special Counsel Jack Smith is saying. Then you've got Pat Cipollone and Eric Hirschman, who worked for Donald Trump in the White House, who had aspects of their attorney-client privilege removed by Beryl Howell as well, by the chief judge of the D.C. courts, and they could testify. Now let's switch gears to speech and or debate clause, the speech and debate clause privilege. That's a privilege that emanates from the Constitution and says that a legislator doing a legislative function, usually on the House or Senate floor, cannot be made to testify about those issues or prosecuted about them. They have immunity related to them because they get to conduct speech and debate as a legislator as part of their job. Mike Pence tried to assert that privilege to stop from testifying against Donald Trump, and what the then chief judge of the D.C. Court of Appeals, who at that moment was Jeb Boasberg, he ruled after an evidentiary hearing we don't know anything about because it was a secret hearing, but ultimately ruled in a written decision that was affirmed on appeal that Mike Pence, at least while he was standing in the well of the Senate on Jan 6th, for those particular ceremonial issues, he's got speech and debate privilege. But everything else, the phone calls he made, the contact with Donald Trump to cling to power, not covered by speech and debate. But Mike Pence, when I hear speech and debate, I think Mike Pence. And so Mike Pence could, at a given moment, try to assert speech and debate. I think the Judge Chutkin, applying the appellate decision and the ruling of Judge Boasberg, who's her chief judge, is going to have to figure all that out before the trial, and that's the point of the motion. But that's not the only member of a person involved in the congressional system that could be a witness, who could have speech and debate that has not yet been resolved by a court system before a jury takes their seat in the box. Scott Perry, representative from Pennsylvania, his phone has already been picked up and all the text messages downloaded. He has not testified to the grand jury nor to the Jan 6 committee, but he is in the thick of it, of trying for Donald Trump to cling to power. coaching Donald Trump on how to do it, counseling him on how to do it, participating in meetings with other insurrectionist types in order to try to cling to power. That's what's been reported in the press already, which I'm talking about here. Other members of Congress, Marjorie Taylor Greene. We know that's already been revealed that Marjorie Taylor Greene went back and forth with Donald Trump in her texting and social media about declaring martial law. She could still allege speech and debate. So you've got the Pences of the world, Scott Perry's of the world, Marjorie Taylor Greene's. Other members of Congress on the Democratic side of the aisle, I don't think would assert the privilege, like Benny Thompson or other people involved with that were attacked on Jan 6th on the Democratic side. I think they're going to drop the speech debate and they're going to testify. It's the Republicans that would put up, the Republican MAGA members that would try to put up speech and debate to stop their ability to testify. And even Jack Smith's trying to protect them from themselves. He's like, yeah, we might have that fight. We might have that academic legal fight about who gets to have the privilege and who doesn't, but not in front of the jury. And that's the point of this motion and in this particular hot take. What Jack Smith's doing to protect the sanctity of the judicial process, to give Donald Trump a fair trial, a fair and impartial trial, one that has all the requisite hallmarks of due process as required by our Constitution. That's what Jack Smith's concerned about, not putting his thumb on the scales of justice and tipping it against Donald Trump. And so that's what the purpose of that particular aspect of the motion is, and the new reporting. Once again, buried on page 19. You got to go all the way to the end, everybody. We do it on Legal AF. We read the motions and the briefing, for even as long as it is, from beginning to end, from top to bottom. We bring it to you in an analysis we like to call Legal AF and the Legal AF podcast. It used to be on Mondays, Wednesdays and Saturdays at 8 p.m. Only on the MeidasTouch Network, this YouTube channel right here. And on audio podcast platforms of your choice. Give me a thumbs up to keep this and this type of hot take and analysis on the air. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.